The Protection of Children from Sexual Offences Act 2012 was enacted to protect children from sexual offences and provide a child-friendly judicial mechanism for dealing with such cases. This act consists of 46 sections in 9 chapters and 1 schedule. In this short video, we are going to understand and learn about the purpose, key objectives, important definitions, punishments, important provisions, important amendments, notable judgments and important questions. Hello sincere aspirants, I am Mayank and you are watching Legal Bites. You can count on us for all your learning and law exams, be it mock test series, previous year papers, real-time practice or PDFs, study material and much more. So this act commenced on 14th November 2012 and it consists of 46 sections in 9 chapters and 1 schedule. This whole video is very important for a quick overview and understanding of the Act. I request you to keep your bare act and a pen and a notebook for an effective outcome. The need for this Act arose in the absence of any such special law which dealt with the protection of children from sexual offences, including but not limited to rape, which simultaneously was gender neutral. The key objectives of the Act is to, number 1, provide a comprehensive law on various sexual offences. Number 2, provide stringent punishments for the enlisted sexual offences. Number 3, devise a child-friendly system for trial. Number 4, to provide every child with the right to get informed about the case in which they are involved. And next, to provide every child with the right to be heard. You must pay attention to some of the important definitions under the Act. Section 2 Clause D defines child. Child means any person below the age of 18 years. Section 2 Clause DA defines child pornography. Section 3 defines penetrative sexual assault. Section 5 defines aggravated penetrative sexual assault. Section 7 defines sexual assault. Section 9 defines aggravated sexual assault. Section 11 defines sexual harassment. Section 13 defines use of child for pornographic purposes. And then Section 28 defines special codes. All these definitions are very important for a clear understanding of this Act. The POCSO Act provides stringent punishment for certain offences such as penetrative sexual assault, aggravated sexual assault, use of a child for pornographic purposes, and for storing pornographic material where a child has been used for creation. Other than the provisions which we have talked about in the important definitions, you must note few of these notable sections, which are Section 16, which deals with the abatement of an offence. Then Section 18 deals with the attempt of an offence. Chapter 5, sections 19 to 23 covers the procedure for reporting of cases, and Section 29, which deals with presumption as to certain offences. This is a very important section. These all are the sections which I have talked about are very important. You must note that and bookmark them in your bare acts for quick revisions. The Protection of Children from Sexual Offences Amendment Act 2019 is a major amendment. The key highlights of the Protection of Children from Sexual Offences Amendment Act 2019 are the punishment for penetrative sexual assault. Prior to the amendment, a minimum 7 years was there, but post-amendment it has moved to minimum 10 years. In case of a child below the age of 16 years, he will be punishable with imprisonment between 20 years to life along with a fine. Then the punishment for aggravated penetrative sexual assault, prior to the amendment, the minimum punishment was 10 years and the maximum was life imprisonment. Post amendment, minimum is 20 years, maximum is even death penalty. See, the punishment for use of child for pornographic purposes prior to amendment was maximum 5 years. Post amendment, it is minimum 5 years. And the punishment for storage of pornographic material prior to the amendment was up to 3 years. And post amendment, it is between 3 and 5 years. There are few of the important judgments which we must take care of. Youth Bar Association of India versus Union of India and others. In this case, the petitioner sought writ in the nature of mandamus. directing the Union of India and all the states for upload of each and every FIR registered in all police stations across the territory of India within 24 hours of registration. Supreme Court issued few notable guidelines which you must note. The accused is entitled to get a copy of the FIR at the earliest. Then the accused has the right to apply for grant of certified copy from Superintendent of Police or as the case may be, the magistrate of FIR within 24 hours. Except for sensitive offences, FIRs are to be uploaded on the police website latest by 72 hours from registration. A 3-officer committee to handle grievances where, in views of the sensitive nature, FIRs are not uploaded. Then in the case of Sampurn Behrua versus Union of India, in this case, the petitioner sought a writ in the nature of mandamus, directing Union of India to ensure that the needs of the children are met and their basic human rights are protected. The Supreme Court again issued various guidelines, and the directions which were there included: the Ministry of Development of Women and Children shall ensure optimal and effective performances of NCPCR and SCPCR so as to cater the needs of the children for their benefit. And for expeditious delivery of juvenile justice, the Juvenile Justice Boards and Child Welfare Committee shall hold regular sessions. Then time-bound surveys must be conducted by NCPCR and SCPCR in accordance with the Juvenile Justice Act 2015. The state government shall ensure that the registration of all child care institutions in order to provide a dignified life to every child. Next is the case of Satish Ragde versus State of Maharashtra. In this case, Satish was convicted for 3 years imprisonment for sexual assault under Section 7 and 8 of POCSO Act by the Sessions Court. The accused challenged this decision in the Bombay High Court, and subsequently the Bombay High Court, while acquitting the accused, held that if there is no skin-to-skin contact, then it would not be considered as sexual assault as provided under Section 7 and 8 of the POCSO Act. The act of pressing breast can be a criminal force for woman or girl while the intention to outrage her modesty. Minimum punishment to be provided for the said offence is 1 year, which may extend to 5 years and shall also be liable to fine. In the next case of Attorney General of India versus Satish, in this case the judgment of the Bombay High Court in Satish Ragde versus State of Maharashtra was challenged and it was heavily criticized. The Supreme Court quashed the impugned skin-to-skin judgment of the Bombay High Court and held that the most important ingredient of offences of sexual assault under Section 7 and 8 of the POCSO Act is sexual intent and not skin-to-skin contact. We have held that when the legislatures has expressed clear intention, the courts cannot manufacture ambiguity in the provisions. It is right that the courts cannot be overzealous in searching ambiguity. We can safely conclude now that the POCSO Act is an affirmative step towards safeguarding of the children irrespective of their gender against sexual abuses and exploitation, and the stringent punishment imbibed therein proved to be deterrent in nature. I hope you find this video helpful. I request you to please comment and share your feedback. And yes, please don't forget to subscribe to our channel as your appreciation and support keeps us motivated. Jai Hind, Jai Bharat. Thank you.